Akwaba so edeba POG Media. So I feel no about Media and so subscribe, like Media and share and a for and so answer and can be kindly click on the notification bell and so send a way out. Yeah, the any news be at a platform so I won't so well no the echo and the eba Jumedia no the donor honum. It's here the bread not yeah but at the era a Torkono sense muna a former and as a retired a Supreme Court a judge Justice Atuguba or a very popular part about the election cases a course of maybe a tribunal or no and then all the other two say hey Torkono like unjai sabi did now you know na did now you know the enko baby a kwan fast we no yes I kwan so or the exposes baby abeto abonten yebeko na yakwakuti exposes papa yi ade betudwa yenko ni kokuti.
Based on the petitions that were presented to the committee, they felt that those were strong enough to cause or recommend her dismissal, but the former Chief Justice doesn't think so.
Were they the only grounds? And even if they were, let us, this is because the Chief Justice is gone. If somebody misappropriates or misapplies public funds, I mean, it's even an offense. Misapplication of public funds, causing financial loss. People are prosecuted and jailed on such things. And are we saying that is proper conduct? If public officers, if they misapply public funds, and prosecuted, are we saying that is improper? It's even criminalized. You know, so I don't know. Charlotte Osei, I think, was removed solely on financial breaches. It wasn't, if I recollect well, conduct wasn't really connected with electoral processes. They were all financial matters. So it was removed.
Do I hear you say that the reasons the committee gave to recommend the removal of the Chief Justice were strong enough for the president to act on it?
As I said, I don't know all of them, but you have mentioned these financial matters. And I don't know, well, from social media, the amounts cannot be said to be trivial. If they were trivial, then of course, I mean, you don't need to be high-handed. But if they are substantial, I'm saying that simply because somebody is a Chief Justice, you are entitled to, you know, misapply public funds and go free. Who are to set the best example? You see, our Constitution is based on transparency, accountability, probity. They are there. And who are to enforce these values? The courts. If the topmost judge will not adhere to those principles, how is it not a serious matter?
So you think that the presidency was right in dismissing her, although this is the first time, and with the 1992 Constitution, that we've seen a Chief Justice removed from office. You should be worried about that.
Well, that is where the problem is. For me, my thinking is different. It's not the person who is involved so much. Although I don't say that it entirely is immaterial who is involved. But, I mean, the Article 146 is the same for superior court judges, including the Chief Justice, and other allied positions, Shraj, Electoral Commission, and so forth. So the same grounds. So, I mean, if financial misconduct qualifies for the removal of an Electoral Commission, why should the same thing, simply because a Chief Justice implied, be taken as trivial? I don't get it.
I heard you say that the fact that she's a Chief Justice doesn't mean that if she's done something wrong, she should be let to go off the hook. Do I take it that you perhaps support the opinion of others who have even requested that she's prosecuted beyond her dismissal?
Oh, well, I'm not, I normally can say that I'm not that type of very strict-minded person. You know, I don't like harsh, you know, visitations of sanctions on people. Humanity is essentially fallible. We have to work within that reality. So if it is trivial, you don't, you know, make it grave to the extent of removal. But if it's not trivial, I mean, what's the alternative? If it's not trivial, it's this a serious matter. If it's a serious matter, why should it be treated non-seriously?
Okay, so she's been dismissed. And per what you're saying, this is a serious matter that deserved her dismissal.
Yeah, if the figures were not trivial, you've heard me.
Yes.
Yes.
You're basing it on the figures and saying that if it is that huge amount of money involved, then perhaps the dismissal is in the right direction.
And you see, it's not even just the figures. It is the, what I call mens rea, the state of mind, the intention. Somebody does something deliberately, knowing that it's wrong and it's not trivial. I mean, what else? What else?
So although you see this as a very serious case, which has eventually led to her dismissal, you also don't think that, or don't support the opinion of those who think beyond the dismissal, she should be prosecuted for misusing public funds. You don't support that course?
I wouldn't go to that extent, because I think the dismissal is enough. The Constitution itself stops at that. It says the effect of the report, if must be accepted by the president, and the sanction is dismissal. That's what the Constitution deems sufficient.
I want us to talk about the process, because there are those who feel that perhaps the process to remove her was not fair enough. You are a lawyer of over 44 years, I mean, standing, and you've been a judge as well, I believe, for over 23 years. What is your understanding of the process that was used, especially from clauses 6 to 11 up to her dismissal? And would you describe that as fair?
Well, in the first place, these procedures were supposed to be in camera, so ask me whether I followed or how could I follow, except they leaked out by chance. They were supposed to be in camera, you know. But what came out in the public domain satisfied the constitutional requirements. Petition is received by the president. If it's not frivolous and vexatious, because Addo and the Attorney General said if the petition is patently frivolous, the president needn't even forward it. But if it is not, then he consults the Council of State. They find that is Addo which introduced prima facie also in relation to it. If it is found, then a committee is set up in accordance with the provisions. The committee goes in, they hear the matter fairly and thoroughly. And then the recommendations, well, I think that was done. So
the process was fair?
Oh, yes. Why not?
But the dismissed CJ doesn't think so.
Do you expect her to think so?
during a press conference, complained about being denied the presence of her family, searches and what she called mental torture, even in a supplementary affidavit. I'll just read a bit of that to you. She said, a complete desecration of my basic constitutional right to a fair trial, violation of my dignity and subjection to inhuman and degrading treatment, a kind not meted out even to accused persons on trial for treason and other offenses against the state. She went on at that press conference to talk about the Edu Lodge, which was used as a place of hearings, and a reminder of how her uncle was murdered, as if to cower her into intimidation and all of that.
But I saw on social media a video when I think that place was refurbished very heavily, and the then president praised its quality and everything. So I don't know. Now I say that if in a certain court, let's say
yo uguswa ohwedwumedie no we your family no message so bejebre na wahwe subscribe, like edwumedie no, share na ma foforo enso can be kindly click on the notification bell no so send be the any new to platform no so I want so we hunu de airco any de airbar intino eja Torkono ana sorry and I say Atuguba etwaso and then some dodo na ide etudwenko ne konkotie
was being tried, or this investigation was in open court, and a member of the family shouldn't be used. I don't know. I really don't know.
So you disagree with her description of the process?
Oh, sure. I mean, these things are neither here nor there. In the long run, it is the substance of the matter that matters. The substance of the matter. Was she given a fair hearing?
She said she wasn't.
Oh, well, I don't know. This was in camera. How did she say she was not given a fair hearing? Because of what I said, bodily searches, and her family shouldn't be there. If the thing is to be, the Constitution says 146(5) plus 5, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. So if it's in camera, has a provision for, allowing your relatives in? Why is that provision?
So she didn't have any cause to complain?
I mean, unless she has a different understanding of what in-camera proceedings mean.
She felt that it was because of the non-fairness of the process, the reason she went ahead, irrespective of the fact that this is supposed to be in camera, to even hold a press conference to update Ghanaians on what she believed was happening. You think that was wrong?
Now, that in itself is a very grave violation of the provision. Is that in camera? You go and hold a live press conference airing what happened in camera. Intent to comply with the Constitution. You yourself, I mean, are you complying with it? You go and hold live conference. And I think before that, appeals were made to the embassies, Canada, what, and I don't see how that is in line. And even at the sense, I think she was requesting for public hearing. When the Constitution is, so, I don't know.
But the public hearing, it wouldn't be the first time such a thing would be requested for, because I know that during the time of Theodora Georgina Wood, her ladyship, there were also petitions to remove her, and the understanding is that there was a conversation with the former president, John Mills, and she requested that if you're going to take me through this process, then let it be public, and that was abandoned eventually.
No, but I'm not sure that because of the public request that it was abandoned. I don't even know that that happened. But the thing is, was that request, whether by Georgina Wood or Torkono, was it in line with the Constitution? So we've read the explicit provision. So I don't know. Now, honestly speaking, you see, assuming even these other things about financial things you are saying, some might say are not great, very breaches of the Constitution during the proceedings are ground enough to remove her. But you are violating, you sworn an oath, you are the Chief Justice, to uphold and protect the Constitution, and you openly violate it like this. Huh? I mean, that's misconduct enough.
Do I hear you say that she was actually the one who brought the entire process into disrepute by her actions and inactions?
Oh, I mean, I'm pointing to particular things. But I don't know what the committee could have done that she would be, because these were in camera. But press conference was an open thing, we all saw it. Appeals to the embassies of Canada, US, whatnot, in the public domain. I don't see how that is in line with the confidentiality clause of the Constitution.
You say that the process was fair, but I want to read to you the page 3 of that presidential seal that was released.
Yes.
And it says that, now therefore, know ye all men, that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of the said Article 1469, do hereby remove the said Chief Justice, Justice Gertrude Araba Isaba Saki Torkono, from the office of Chief Justice and Justice of the Supreme Court with effect from the date thereof. You say the process was fair. Is it fair to remove somebody who is being investigated as Chief Justice, not just as Chief Justice, but also as a judge of or a Justice of the Supreme Court?
Look, the moment you become Chief Justice, you don't hold two offices, one as Chief Justice and one as Justice of the Supreme Court. Let me read the composition of the Supreme Court to you. 128 clause 1. The Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. So, I mean, from this provision, it means that the Chief Justice is considered as a Justice of the Supreme Court. In her right as Chief Justice. The others two are Justices of the Supreme Court. So let's go by common sense. I mean, are we saying that the time she was Chief Justice, if somebody wanted to know the number of justices on the Supreme Court, you say, oh, there are 14, because you have the Chief Justice who is 1, and 2, the Chief Justice in her capacity as Justice of the Supreme Court, those are 2 people. I mean, it doesn't make common sense. And from the provision, I mean, she is a Justice of the Supreme Court in her capacity as Chief Justice.
So the point you're trying to make is that there is nothing unfair about removing her as a Chief Justice at the same time as a judge, because it's the same person.
Once she is removed as Chief Justice, that's all. She's not holding a split position. She's not a split personality. As for the provision I've read to you, the Supreme Court shall consist of the Chief Justice and 9 other justices. So she's a Chief Justice. She's a Justice of the Supreme Court in her right, in her position as Chief Justice, and then 9 others. So I mean.
All right, and those are bits from an extensive interview conducted by Beatrice Edu with Justice Atuguba on the matters arising from the removal of the Chief Justice Gertrude Torkono.
Ajebo enyaba bedru aha ene de djubadie no ebesi edema message so be subscribe like djubadie and share nema for friends and can be kindly click on the notification bell so send be ya the any news be to platform no so also well no the airco and the POG Media the Mahama say no crefie makramo.